We're now focusing on about 100 people that somehow can be related and linked to the downing of MH17 or the transport of the book. Out of these 100 people, we've been able to establish the identity of a number of people. These are persons that played an active role in obtaining the book teller and organizing the transport to the firing site. And there are also persons who have aided, facilitated this, or had a supporting role. These are also the people who escorted the transport of the book teller. These people are not all automatically suspects. In order to assess whether these persons acted culpably and can be earmarked as suspects, it's important to understand the hierarchical structure of deploying the missile. Who ordered the book teller to be brought in, and who ordered the flight MH17 to be shot down? Was it the crew itself, or were they executing orders from higher up? The equipment that you're referring. So on this footage, Your Honors, we could see that in front of dozens of television cameras, the chief public prosecutor and the head of the Criminal Investigation Service took the floor, and the conclusion is, in September 2016, that the air-to-air scenario can be ruled out, and that the JIT reaches a conclusion with certainty that a book missile was used of the 9 M38 series, and that this book was brought in from the Russian Federation. Furthermore, a specific firing site is mentioned, namely the farm field, that the current indictment also refers to. The exact circumference of the farm field is mentioned and showed as well as the exact location. The exact name of the town near the farm field is mentioned on several occasions, and the language that is used, such as conclusively, prove, and without any doubt, has a very important connotation for people who are not legally trained. The question from a journalist whether the findings of Almas Ante during the arena test could make a contribution to the investigation. The answer to that question is that this material will be looked into and will be incorporated in the case file, but at this point in time will not lead to any other conclusions in view of the overwhelming amount of material that is available concerning the scenario they chose themselves. So in September 2016, there's a strong belief that they are right, and so therefore the information with respect to the manufacturer of the book missiles is set aside. As we now know, the field test report concerned has initially not been incorporated in the case file, as opposed to what was announced at the press conference after efforts and requests from the defense. This report is now part of the case file, and this is typical, as far as we're concerned, of the approach of the Public Prosecution Service. Regarding the question that was raised at the press conference, whether assessing available wreckage, but that is not wreckage that was not used, whether that could contribute to the investigation, and the answer to that question, well, that will be discussed when we discuss question 2 in our oral arguments. The fourth JIT video is of a press conference on 24 May 2018. And at this press conference, once again, the public prosecution scenario is repeated as being the outcome of the JIT investigation. On this occasion, specific matters are mentioned, such as the type of missile, towns, etc. In addition to that, the 53rd Brigade is mentioned as being the supplier and executor of the missile launch. And I'll show you parts of this press conference now.
On the 28th of September 2016, the JIT presented the initial findings of its criminal investigation into the downing of MH17 on the 17th of July 2014. However, a lot of progress has been made since then, notably in identifying those who were directly involved. On the 28th of September 2016, we referred to a group of about 100 persons who were linked in one way or another with the downing of MH17. Now, considerable progress has been made in this connection. The role of a large number of those individuals is now much clearer. The JIT has come to the conclusion that the book Taylor that took down MH17 originated with the 53rd Air Mobile Brigade. That is to say, the 53rd Air Mobile Brigade from Kursk in the Russian Federation. There are 4 questions. Who were the members of the crew? What were their instructions for this mission? Who was responsible for the operational deployment of the book Taylor on the 17th of July 2014? And finally, who can give us more information regarding procedures and those who bore command responsibility within that brigade? Ladies and gentlemen, I'm going to tell you more about the type of missile which downed MH17. As you know, it is a 9M38 series Buk missile. Fragments of the missile was found in wreckage at the crash site and in the remains of the victims. All of this forensic information confirms earlier findings of the JIT that MH17 was downed by a Buk missile of the 9M38 series. I'm now going to bring your attention to 2 particular components of such a Buk missile. You have the venturi and the casing. The venturi is the exhaust element of the missile. The casing is actually the housing of the missile motor. Both a venturi and a casing was found in Ukraine. I have a question for Mr. Vesterbeek. You had about 100 people you were looking into. How many are you still interested in? And are any of these individuals of the not Russian nationality? Well, I've already stated in my presentation that we have received a great deal of extra information over the most recent period of time. We started off with a group of about 100 a year and a half ago. We've been able to reduce that number from 100 to just a few dozen. I have a question for Mr. Vesterbeek. Have you tried in any way to summons those individuals in to be interviewed? And if you have not, why not? Why has it not been possible? If you're pretty clear on the group of individuals you're interested in, why haven't you been able to speak to them? Well, we have been focusing on identifying the individuals who know more about this book, Taylor, who know more about it, who are members of the chain of command. And actually interviewing those individuals, approaching those people, is an upcoming step. But right now we're at step one. Now, Your Honours, it's clear from this video that there were 4 questions regarding the 53rd Air Mobile Brigade, but those questions have not yet been answered. They remain unanswered today. That is to say, who were the members of the crew, what were their instructions, who was responsible for the operation deployment of the book Taylor, and who were the commanding officers or superiors within the 53rd Brigade. Now, of course, these questions are highly relevant against the backdrop of the prosecution scenario. However, despite the fact that those questions have not been answered, the choice has nonetheless been made to prosecute our client. In addition, we note that in this video, a so-called casing and venturi were shown to the world press. They had been found in eastern Ukraine in April 2015. Now, throughout the press conference, the casing and the venturi had a prominent position on a raised podium behind which the JIT representatives sat. And then at the end of the press conference, the press photographers from the world over had the opportunity to photograph them. And of course, that was the whole purpose. Now, the way in which the casing and venturi were presented and the commentary which was given on them undoubtedly gave the public the impression that these components were part of the missile that, according to the JIT, downed the aircraft, and that the JIT had parts of the murder weapon, as it would be dubbed in the press, in its hands. Now, this choice of presentation will have once again solidified in the public mind that there was no other scenario than the prosecution's scenario. Things were, however, very different 3.5 years later in December 2021, when the prosecution presented its case. When presenting its case, it did not even mention the venturi and the casing. And they were not even mentioned after the defense pressed the prosecution to take a stance on them one way or the other. So, were these components part of the Buk missile which allegedly took down MH17 or not? We'll discuss that in greater detail when we focus our attention on question 1. Now, the 5th video that I'm going to show you is from the most recent press conference, which took place on the 19th of June 2019. At that press conference, the photos and names of the 4 suspects were announced to the international press. This press conference was also broadcast live on Dutch TV. Ladies and gentlemen, on the basis of the Joint Investigation Team's investigation, we have decided to prosecute 4 individuals for the downing of flight MH17. This marks the beginning of the Dutch criminal prosecution. The Dutch Safety Board issued its final report some time ago. The board investigated the cause of the crash and concluded that the MH17 had been shot down from the east of Ukraine by a Buk missile from the 9M38 series. Now, the 4 individuals that we consider as suspects are suspected of transporting the Buk Taylor system into eastern Ukraine. We will now tell you who those individuals are. Today, we will be issuing international arrest warrants for the 4 suspects who we are prosecuting. We will also be placing them on the national and international wanted lists. We will announce their names and show their photos. Oleg Pulatov, Oleg Yuldashevich Pulatov, also known as Yurza, born on the 24th of July 1966, is a former soldier from the Spetsnaz group, which is the Special Forces unit, which is part of the Russian military intelligence service. Oleg Pulatov was deputy head of intelligence and one of Dubinsky's deputies. Suspect Kharchenko was under the command of Dubinsky. As a commander, he was a leader of a military unit in the region. We have recently informed the court that we intend to prosecute, and we are currently focusing on completing the case file, notably the digital elements thereof. We hope to transfer that case file to the court at the end of the year. The court has informed us that the trial will open on the 9th of March 2020 at 10 a.m. Based on that discussion and based on other investigation results, it appears that not only the book Taylor, but also the crew came from the Russian Federation. I'm going to now play for you a conversation which took place between suspect Kharchenko and an individual called Ryazan, and who refers to Kharchenko as being a commander. This was recorded on the 17th of July 2014. So Kharchenko orders the person he's speaking to bring a crew member to him. Now, the JIT would like to know who was that crew member. We want to know who was involved in making the decisions in the Russian Federation, and we want to know what the remit was of the Air Mobile Brigade, which was sent to eastern Ukraine. The questions that the JIT wishes to answer is who decided that the book Taylor with the 3 and the 7 marked on it should be deployed in eastern Ukraine. Secondly, who decided which individuals would make up the crew? Which mission and instructions were issued to the crew, and who issued it? I would like to know how you managed to disprove or refute that the rocket belonged to the Ukrainian army. It is well known from official documents that it was in the possession of that army since 1986. And a follow-up question. The Joint Investigation Team said that it had received Russian radar data and that it had been analysed by the 2 experts. And that those 2 experts had said that they had found no practical use in it. Could you tell us who those experts were? From what organizations were they? What was their experience? And what were their qualifications? And what was the exact practical nature of their analysis? Thank you. I'm just going to say a few words regarding this video, and then I think it would be time for lunch. So, well, it's not surprising that at these press conferences, you have the information summarized and repeated. It is boldly announced to the international press that a member of the crew of the 53rd Brigade had shot MH17 out of the sky shortly before. You heard it said just there. Once again, the questions are put as to what was who made up the crew, what was the specific mission of the crew, who were the commanders in that crew. Those questions remain unopened. Now, one of the journalists asked how the JIT had confirmed that the casing that had been shown at the earlier press conference had been in the possession of Ukraine since 1986. Well, the answer was that what was on file and the contents of the administrative documents, the logs available, was unclear and had been placed in the case file so that the judges could decide upon it. It is also clear from the case file that the JIT has not interviewed individuals from the Ukrainian side to ascertain whether the missile was indeed in the possession of the Dutch army at that time. Rather, the SBU was asked to investigate whether the Ukrainian army had that missile in its possession at that time. And that yielded two letters, which one dated 4 months before the other. And those letters said two different things, and they certainly would have been a reason to investigate further normal conditions. First of all, one answer was that there was no registration information regarding the missile, and the second one was that there was indeed administrative data, but that the data from 1985 to 1991, let's remember that the missile was said to be delivered to Ukraine in 1986, and the logs from 2009 onwards had been destroyed or was absent. And let's remember, of course, that the facts in this case took place, or the events in this took place in 2014. And we also saw in this press conference that the names and photos were shown of the suspects, and it was even announced that this trial would open on the 9th of March 2020, although back then on the 19th of June 2019, no attempts had not yet been made to interview our client. So the conclusion I draw from these videos, which were largely JIT videos and one DSB video, they leave little to the imagination. It is proclaimed with great certainty and without qualification that the scenario presented as of December 20. That the scenario presented here in court in December 2021 by the prosecution was the one and only scenario. The narrative also included, for example, the so-called birdie conversation, which will have marked criminal perception of what happened in this case. However, I believe that in this very courtroom, the prosecution stated that it is now considered that Birdie's conversation did not relate to the MH17 events. And I leave it here, Your Honours. Thank you very much. We shall take a break now until 2 p.m. I note that two of my colleagues have not yet received actually a printed copy of your pleading notes. Perhaps you could arrange for copies to be provided for them also. Thank you very much. We shall break now for lunch until 2 p.m. and politicians. Well, politicians in the Netherlands have not been silent on this matter either. I'm going to refer to a number of reactions that we have heard from Dutch politicians, and I'll go through those in chronological order. These are comments and reactions to the DSB report and the JIT press conferences. And after that, I'm going to go on to the interstate complaint that was launched by the Netherlands at the ECHR, amongst other things. So starting off with the after the DSB report, well, a press conference was given by the Prime Minister here in the Netherlands, and there was indeed a parliamentary debate after that. And during those press conferences, including those of the Prime Minister, the impression was given that it was now known what type of missile allegedly took down MH17, and alternative scenarios were excluded. There was much talk with great conviction and gusto in the House of Representatives here in the Netherlands regarding the responsibility, as they claimed, of pro-Russian rebels who were in control of the area at the time. After the press conference, which was given by the JIT and the Public Prosecution Service on the 24th of May 2018, the Dutch government made statements that were of quite a specific nature. The former Minister of Foreign Affairs stated that the JIT's findings were such that it had now been determined that Russia was responsible for the deployment of the Buk installation, which had downed MH17. One day after the JIT presentation, there was another press conference given by the Prime Minister here, in which he said that the findings that had been presented by the JIT had been compelling and that they had demonstrated that the Buk installation had been used to down MH17 and that that installation had been in the possession of the 53rd Air Mobile Brigade from Kursk, and that there were no doubts whatsoever possible about that. And then on the 25th of February, recently in fact, the Prime Minister referred to that press conference once again in an interview he gave on the Dutch public television channel. He said in 2018 it had been objectively established that Russia was behind the downing of MH17. Now, during the parliamentary debate which took place after the press conference, the former minister, or the Minister of Justice at the time, said that there was little doubt as to what had taken place, and he was very clear on the position of the Dutch government. He said that it had been a decision taken by the cabinet to hold the Russian Federation liable for its involvement in the downing of MH17, and that decision had been taken by the cabinet based on an analysis which had been carried out by the Ministry of Foreign Affairs. According to him, that analysis had been based on information that had been provided by the Public Prosecution Service, amongst other sources. That minister also said during that parliamentary debate that the Buk tailor, which had downed MH17, had been from the 53rd Air Mobile Brigade. MPs concurred with what he said and, for example, declared that the net was now closing in on the potential perpetrators. Also, at later points in time, the Prime Minister, at various press conferences, said that it had been demonstrated that the Buk system had come from and had been returned to Russia, and that there was compelling evidence thereof. Then, at a hearing on the 3rd of November, or at a sitting on the 3rd of November 2020, or at the hearing here on the 3rd of November 2020, we reported the fact that in a letter to Parliament dated the 10th of July 2020, the state of the Netherlands, or the Kingdom of the Netherlands, had informed the House of Representatives that it had lodged an interstate complaint at the European Court of Human Rights against the Russian Federation for its part in downing the MH17. In that self-same letter, it was said that this legal action taken by the Dutch state also provided support to individual complaints being filed by relatives of the victims. The Cabinet referred to recent developments in the criminal proceeding in relation to its decision to launch an interstate complaint. Then the Prime Minister, in response to a question from journalists, said, well, basically what we're doing is filing a complaint, an interstate complaint at the European Court of Human Rights, claiming that Russia played a role in the downing of MH17. When it comes to the criminal procedure, well, that is a criminal procedure to investigate, identify, and prosecute those who actually perpetrated the crime. The criminal proceeding does not relate to Russia, but to individuals. He also went on to say that the criminal trial was a matter of dealing with the perpetrators themselves and finding means to bring them to court. So these comments made by the Prime Minister and by politicians, and the letter of the Dutch state to the Parliament, and indeed the content of the interstate complaint which was filed, make it absolutely clear that the Netherlands has chosen a side in this matter and has been very public on its position, and has done so while this trial continues to take place, and although this trial has not yet concluded. At a recent hearing at the European Court of Human Rights, the Dutch government has also adopted very specific positions which are based very clearly on the prosecution's case. And you can actually view that hearing at the ECHR online. The Dutch government stated that the Boektader had been delivered to the separatists together with a Russian crew, and that it had been delivered via Snezhny and deployed in an agricultural field near Pervomaisky. Now, all of this leads up to the Dutch government actually drawing conclusions and presenting them in court. So according to the Dutch government, there is compelling evidence that Russia was involved in the downing of MH17. So based on all that I have just said to you, and based on these statements made by the Dutch government from 2015 time and time again, and this in conjunction with the filing of an interstate complaint, makes it absolutely clear that the Dutch government publicly supports and agrees with the stance of the prosecution in this case. And these positions adopted by the government here in the Netherlands relate to questions 1 and 2, as you have defined them in these criminal proceedings, questions that are still before this court. All of this puts further pressure on the outcome of this criminal proceeding. And so it is that these factors have in fact raised the expectations of the outcome of this trial. In order to clarify the motives, what has motivated the Dutch government to file its interstate complaint, to know more about the timing of the filing of that complaint, and to ascertain whether the Public Prosecution Service was consulted or involved in the decision-making process of the government, to gain more information on that, we have submitted written questions to the public prosecution and the Dutch government, using public information channels to us, open to us. We have received no answers to those questions. The Public Prosecution Service has offered no more than the short comments which we heard on the 13th of November 2020, and the national authorities have not provided any further information on how they arrived at their decisions. Rather, the decision-making process seems to be being categorized as a state secret, as a result of which all our objections to information not being provided have recently been dismissed. By letter of the 27th of January 2022, we're being told that the information that we're seeking is confidential. For now, we just have to accept that the Netherlands refuses to be held to account on these matters. However, an appeal has been filed by us with the court against that decision by the state not to answer our questions. We have filed an appeal to dismiss that decision. The interstate complaint and these criminal proceedings do indeed basically deal with the same facts. However, the actual legal aspects and technical evidentiary aspects are different. It seems that the Cabinet felt that back in June 2020, when the prosecution made its case clear in this court, the government felt that it was the right moment to file its interstate complaint. So we see there a link between what is going on in this court and actions being taken by the Dutch state with respect to the ECHR. There were undoubtedly discussions between the Public Prosecution Services and the Ministry of Foreign Affairs. It's the Ministry of Foreign Affairs which is party to the ECHR proceedings. Now finally, and I'm now moving on to a different topic, I have a word to say about other expectations with respect to this trial. I think that it's relevant that I report that long before this court has issued a judgment in this case, the Dutch authorities have already awarded distinctions, honors, to the prosecutor who represented the Netherlands who signed the JIT agreements on behalf of the Netherlands, and also the team leader for the Netherlands in the JIT. Now, I won't state their names here, but those individuals have both received royal honours inter alia because of their work on the MH17 case and because of their role in uncovering the facts. Now, the text of stated by the Minister of Justice when awarding this honour to those individuals was that these individuals had secured the case against the suspects. And this, as I say, in anticipating, it would seem, the judgment by this court.
Now for public opinion. We are not claiming that our summary of all the circumstances which conspire to impose extremely strong presumptions about the outcome of this trial is complete. We have not mentioned years and years of national and international journalistic reports of what seems to have happened. This journalism is of extremely extensive and went on for an extremely long time. We have touched briefly upon the reporting by the JIT, the Dutch government and the Public Prosecution Service, all of which have already answered the three main questions of this case in the public mind. And the Council for the Relatives' presentation of their claims on the 8th of December last accepts the JIT's theory unconditionally. Council for the Relatives most emphatically and unreservedly joined the long procession of people who believe that we've all been long aware of what happened and who's responsible for it. Their presentation preempts your court's verdict with scant care for the principle of innocence until proven guilty. Even worse, their presentation contains errors of fact. For example, they have repeatedly asserted that the defendants have shown no empathy and no gesture of sympathy towards the relatives. And that is quite simply not the case. Pulatov's two video statements address the relative suffering extensively. I've got the actual quotations from him in my pleading notes. Now, since the Public Prosecution Service did show these videos during its statements, I will not quote them at this stage. I'll simply draw your attention to the following quotes from them, well, in that report. But as far as we're concerned, the presentation crosses a line with the statement that the defendants actively helped to prevent the timely repatriation of the bodies, which as a result lay out in the field longer than necessary. Let me explain why I think this. The Counsel for the Relatives presentation bases its allegation on the fact that conversations don't mention repatriation. This fact is certainly not enough to lead to their very grave conclusion. Firstly, we all know that a great deal of the communications from that time is not on file. And secondly, as we all know, an argument to the contrary is not the same as proof of a fact. Thirdly, the file contains telephone conversations which do indicate that immediately after the catastrophe, authorization was given to the OSCE to enter the crash site. And fourthly, there is nothing whatever in the file to show that Pulatov, as an individual, had any authority or was involved in the decision-making regarding the repatriation of the bodies in the very complicated situation on the crash site after the crash took place. Finally, when talking about public opinion, I'd like to draw your attention to an interview that took place on the last day of 2021 in the NRC newspaper. Here, one of the investigating judges in this case is interviewed about the prosecution statement, and this interview is used to influence public opinion. In the interview, the case before us today is described by the investigating judge as a terrorist case. It said that the driving motivation of the prosecution was to imprison the criminals. The judge praises the researching team and Bellingcat and says that defence hadn't had much to add because the prosecution had constructed the case in such a way that they were essentially acting as defence counsel. That's what the judge said in the interview. In response to a suggestion made by the NRC newspaper to the investigating judge that justice hasn't yet come up with much, a judge might be expected to explain to readers unfamiliar with criminal trials that the defence can only express its positions and defences when it comes on to pleading, and that you have to wait for that to happen before you can draw any such conclusion. Instead of that, the NRC's attitude is confirmed by pointing out that all other possible scenarios have been investigated. As defence sees it, the prosecution in any case should have asked itself whether 3 days of presenting its case, and in particular before we had pled, it was appropriate to give the interview at all. Particularly since, after the prosecution's presentation, the court explicitly drew everyone's attention to the importance of defence in a Dutch criminal trial. The desire to look good in public yet again clearly took precedence over what is considered proper under the rule of law. This brings me to wrap up this section of what I call the context. All the circumstances that I have run through conspire to put the outcome of this trial under unprecedented pressure to satisfy public expectations and demands. In many minds, the verdict is a foregone conclusion. And the defense of a defendant in this case is just a necessary evil or a concession to legal requirements. In the light of all these circumstances I've sketched out, the prosecution and the Dutch government, using their press conferences, statements in the press, the interstate complaint, have all created a climate where no other ideas about these events will be accepted. In these circumstances, more than any other, the defendant's legal protection against the authorities must be of the highest quality in order to avoid mob justice. I'll now move on to the next topic. And here I'll just say first that it's quite a lot that I have cut out, but I'll tell you when I've skipped bits by referring to the paragraph numbers. And that's because a great deal of what I was going to say has already been dealt with in the more specific part of the pleading. And the topic here is that the other scenarios were not investigated in an equal way. The alternative scenarios were not scrutinized as thoroughly as the scenarios on the charge sheet, neither during the investigation nor during the hearings. And here, I'll just make some more general comments on this subject. There's a number of alternative scenarios. I won't do this. I'll come back to that at a later stage. I'll now move on to paragraph 140. If you just look at the number of pages dedicated to the scenario on the charge sheet compared with the other scenarios, you can see the comparison. The alternative scenarios take up 7 pages of the overview document, whereas the chosen scenario has 75 pages, with the occasional mention of other alternatives. The overview document starts off by saying that during the investigation, they'd quickly come to suppose that the MH17 had been shot down using a Buk missile. Exactly when that supposition arose is not stated, but from the look of the investigation, it would appear that it can't have taken very long. I've already quoted today that on the 1st of October 2014, a very early stage, 2 Buk missiles were dismantled in Ukraine. The decision to do that and all the preparations must have taken some time, and we can therefore conclude that this supposition I mentioned must have arisen in mid-August 2014, or even before then. Now, since the overview document indicates that the telecoms made available to the investigation team contributed to that supposition, and that some of the telecommunication had been placed on the internet by the SBU, it seems likely that the scenario on the charge sheet was already establishing itself in the minds of the research team. Among other things, there are 6 video clips in the file, which were put on the internet by the SBU shortly after the crash. It was almost 20 minutes of material and dozens of intercepted phone calls. And the very rapid publication of this on Ukrainian at War website will also have contributed to this. In addition, lots of news reports appeared within an hour and a half of the MH17 crash. And here it is striking that the Ukrainian government answered what the charge sheet now says as early as the 17th of July 2014 at 5:53, 6:07 and 7:12 p.m. And that's where I'd like to skip a passage now, and I'll move on with 185. And we'll let you have that in due course in our computerized version. Brings me to the 5th section, restrictions in the investigation. And here I'll start off with the first sub-paragraph, no valid forensic investigation in Ukraine. And this is paragraph 185. On a number of hearing days, both the prosecution and defence have explicitly mentioned the restricted opportunities for investigations.
Has spoken at length on the various ways in which a full and complete investigation could have taken place. What is important to note is that it was not possible or barely possible for a proper forensic investigation to take place at the crash site into the alleged launch sites. Of course, a number of different locations have been identified over the years. As part of the forensic investigation, at certain places, soil samples were taken, but because the reference material in terms of soil samples did not contain residue of scorching, it was decided not to analyze the soil samples taken by the JIT. Also, the period of time between the taking of the reference samples and the investigation thereof was longer than the time between the taking of the soil samples and exploitation thereof by the JIT. And so that is what we read in the investigation overview report. So what this means basically is that there is no forensic information regarding the launch. The DSP, in its video, showed a certain launch area, but stated that further forensic information was necessary to learn more about it. The fact of the matter is that the forensic investigation has not been possible to provide that extra detail. However, the allegation that location 1 was a possible site from which the missile was launched. However, no attempt has been made whatsoever to further investigate that. There was also telecoms data available, but it appears that over the course of time, the conditions for analyzing the data available has deteriorated. As a result, the measurements were taken at quite a late point in time, and therefore any findings based thereon need to be viewed with caution. It is also noted that the fact that a telephone communicates with a transmission mast does not mean that the telephone was in the vicinity of that transmission mast. That has been accepted. The prosecution tells us that there is it is in fact necessary to be cautious, and it is not reasonable to take the sole fact that a telephone communicates with a particular transmission mast as proof of presence of that phone at a specific location. However, in the prosecution's case, we don't see much caution. Rather, dozens of times we see the term communication and supposed communication therewith appearing in large numbers of images. Now, I'm going to return now to the chronology of the investigation. The conclusion is that the limited investigation which the Dutch investigators had carried out on site yielded barely any usable direct evidence. Now, that is in and of itself problematic when it comes to the reliability of the understanding of what took place. There were also next to no interviews of local residents, and even if local residents were interviewed, it seems that nothing was committed to paper. And therefore, we conclude that possible very useful testimony has been lost. Those witnesses who did make statements made their statements after vast amounts of information had been provided on the internet, over television, in television channels, press channels, etc. Thereby meaning that what they've had to say was undoubtedly open to contamination from those sources. Then there is the issue of the of course, given the type of case, forensic evidence is extremely important. But in this particular case, there's this huge handicap in that the forensic history of much of the material is unknown or is unsure. Now, I'm going to talk about the circumstances around the circumstances surrounding the disaster site shortly after the 17th of July 2014, and the way in which wreckage, etc., was recovered. Now, the prosecution told us much about the conditions on the ground in June 2020, but let me basically summarize what they said. The securing of the crash site and the recovery mission took place under the leadership of the OSCE and not under the supervision of the authorized Dutch investigators, as would be normal in a criminal case. Depending on the situation in the field, it was decided on a day-to-day basis whether a particular part of a crash site could be accessed or not. And for that reason, it was not possible for all areas of the crash site to be investigated fully. It has also been described how investigators from the Forensic Investigation Service had no access to the crime scene initially after the crash. Also, the forensic investigation largely took place in the Netherlands and not in the field. It is also relevant that much of the material, of course, had to be transferred and transported to the Netherlands, and that transportation activity did not take place flawlessly from a forensic point of view. Evidence undoubtedly went missing or was contaminated in the process. It's also not a secret that many people were present on the crash site, aside from local people. There were also members of the emergency services, members of the state emergency service, that is to say the SES, the fire brigade, the police, other people providing assistance, representatives of the OSCE, journalists, interpreters, escorts, Ukrainian and Malaysian aviation investigators, identification and repatriation workers from various countries, and indeed relatives of the victims. And it is known from open journalistic sources that items of wreckage continued to remain at the crash site long after the recovery operation. Now, all of the wreckage which was actually repatriated to the Netherlands was investigated in depth there, and findings have been produced thereon. There is a list of all types of wreckage which was found. Now, in the case of a large number of these items of wreckage, the prosecution has, however, admitted that it cannot be excluded and that some of those items may have already been on in the location prior to the crash, or may have arrived at the location after the crash. Now, it cannot. So the prosecution cannot know exactly what was present on the 7th or appeared at the site on the 17th of July 2014 alone. Now, in the Netherlands, it is most unusual and almost taboo to talk about planted evidence. But in this case, with such an exceptional crime scene and with such weighty interests of warring parties, it's actually not such a strange phenomenon to consider. In fact, that is the price to pay in evidential terms when jurisdiction is exercised in conflict zones far from the Netherlands. When establishing truth, it is very important to ascertain whether material collected is or is not related to the scenario alleged. Is it possible that the material was already at the place, or that it only later appeared at that place or was placed there intentionally or came to be there accidentally? These are crucial questions in a criminal investigation. The only report that can illuminate us at all on this is that of the DSP, but I will show you that it is, in fact, that report, in fact, only adds to the lack of certainty. It can be inferred from the DSB report that initially, after the MH17 crash, it was not possible to carry out an extensive investigation of the crash scene. That resulted in wreckage being left unsupervised in the crash area even after August 2014, until it was recovered. So, as I said, these materials were simply left there and therefore could, according to the DSB, have been damaged, could have been deteriorated due to weather conditions. Given this situation, in the report it is stated that the situation in November 2014 was no longer that which it was immediately after the disaster. So the DSB already in its report was clear on the limited value of the wreckage. And there's also wreckage which had been at the location, which we have seen on photo, which was not recovered. Furthermore, it was not possible to gather all of the wreckage that was on the priority list, not least because not all parts of the disaster area was open to be accessed. As to which items of wreckage from that priority list could not be recovered, that's not clear, because that is, however, a table in the DSB report which lists wreckage which was not repatriated. I move on now to paragraph 213, which is the explanations given in the DSB report. We have the upper left-hand side of the cockpit. Now, we've heard much about this. We expressed our own wishes with regard to the investigation that would be done. It is a relevant part of the wreckage, particularly when it comes to ascertaining the location of the launch site. So, on the upper left-hand side, we read that there are bores, there are perforations from the outside into that piece of wreckage from the fuselage, but that part of the wreckage is not fully available. Then there is the front side of the fuselage, which was in two pieces. According to the DSB, it says that the upper part had perforations from outside, but those parts were not recovered because, according to the DSB, they were no longer on site during the recovery operation. Then we have there is a part that was found at location 1, but was no longer available at the time of the recovery. Then there was the left-hand side with door frame L. That part was also not found. The right-hand side of the fuselage, that part was also not available for recovery. The passenger section to the fore, so the business class, was also not available during the recovery mission. Now, the DSB, therefore, has made it absolutely clear that some items of wreckage had disappeared or simply were not recovered. On page 66, it says that evidence in the form of photos and videos taken in the days after the crash show that location 3 had been disrupted and that aircraft wreckage and baggage had been removed from the location. A number of aircraft electronic components, after being photographed, were no longer present on site at the time of the recovery operation carried out by the DSB in November 2014. Now, according to the DSB, it was only necessary to reconstruct the front part of the aircraft because this was the most relevant when it comes to the reason for the crash and the damage on the fuselage. We find that questionable. We have read in the TNO reports, for instance, as well as in the DSB reports, that the DSB had only recovered 20 to 25% of the aircraft. The TNO staff believed that the damage pattern could not be completely seen because large parts of wreckage were missing. Because of ongoing conflict, certain aspects of the forensic work could not be carried out, the type of forensic steps that would normally be taken on a crime scene. Now, after May 2015, when recovery of the remains of the victims and the wreckage had largely been completed, the prosecution said that it was not useful to collect any further material for the forensic investigation. Not all investigative objectives could be fulfilled because the Public Prosecution Service was unable to operate in the DPR-controlled area.
Okay, let me find my place. I think we can just
Yolanda,
carry on and then we can be ready in time for the break.
On the
I
break,
now talk about section
we're going to
5.4.
go to section 5.4.
Talk about 5.4, which is the question of the book Missiles in the section on limitations to the investigation. The evaluation of the forensic material, whose precise source is largely unknown and uncertain, is hugely dependent on Dutch experts with little or no experience of ground-to-air missiles and the warheads they carry. This experience becomes clear enough in the written and oral questions put to any given expert, and we will come on to discuss them extensively when we address question 1. Since the Netherlands has as good as never researched missiles of this kind before, let alone in criminal cases, this experience is no surprise. One wonders, of course, why the Dutch Public Prosecution Service didn't turn to an internationally recognized institution, more experienced and better informed in the field, but decided to stay in The Hague as the NFI's preferred supplier. Furthermore, in the years running up to 2014, a number of critical articles and reports had appeared about how the NFI was excessively loyal to the Public Prosecution Service. One parliamentary investigation committee reported in October 2018 that most staff said their department was overworked, that work was sometimes done with no clearly agreed plan of investigation, and their findings were not always documented in the correct way. And this report covers the very period during which our case was under investigation. Finally, parliamentary papers and other sources say that the NFI stance is reactive. You ask, we deliver. What they mean is that the NFI strictly answers only the question asked and looks no further than that, and it cannot, on its own initiative, carry out any investigations which would logically arise from its findings. We'll come back to this when discussing question 1. I'll now come back to the investigations themselves. Another restriction was also that particularly information on warheads in military air defense missiles is almost always classified. That means that research into these warheads relies on open sources and does not meet the standards demanded in order for it to have any evidentiary value. The Dutch investigation in question, RC06, says the same thing in his own reports when he says that he was asked to do the impossible, that he had to revise his findings twice, and was extremely cautious in his conclusions. We will come back to this as well. Now, my conclusion regarding restrictions in the investigation. In the light of all these circumstances which hampered the investigations in our case, it was very bold to allow the experts to work with only book missiles as reference materials and to calculate the launch site using only the new type of book missile and the new warhead. The risks attaching to these investigations and their consequences in this case will be addressed specifically later in our pleadings. Finally, the forensic history of a great deal of physical material is not known, and that will indubitably affect its usefulness. And again, we will come back to that when discussing question 1. And this brings me to section 6. Yes, I think this is the time to have a break. It's almost 10 to 3. We'll have a break until 3:30.